Welcome back. We're up to Volume 2 of the Mueller Report audiobook report on the investigation into Russian interference in the 2016 presidential election, Volume 2 of 2. Very exciting to have Volume 1 complete. See the previous 10 videos if you haven't read or listened to Volume 1. We're up to Volume 2 now. Scrolling through the table of contents, we'll get to page 1 and commence our journey to the end of Volume 2. Introduction to Volume 2. This report is submitted to the Attorney General pursuant to 28 CFR 608C, which states that at the conclusion of the Special Counsel's work, he shall provide the Attorney General a confidential report explaining the prosecution or declination decisions the Special Counsel has reached. Beginning in 2017, the President of the United States took a variety of actions towards the ongoing FBI investigation into Russia's interference in the 2016 presidential election and related matters that raised questions about whether he had obstructed justice. The order appointing the Special Counsel gave this office jurisdiction to investigate matters that arose directly from the FBI's Russia investigation, including whether the President had obstructed justice in connection with Russia-related investigations. The Special Counsel's jurisdiction also covered potentially obstructive acts related to the Special Counsel's investigation itself. This volume of our report summarises our obstruction of justice investigation of the President. We first described the considerations that guided our obstruction of justice investigation and then provide an overview of this volume. First, a traditional prosecution or declination decision entails a binary determination to initiate or decline a prosecution, but we determine not to make a traditional prosecutorial judgment. The Office of Legal Counsel, OLC, has issued an opinion finding that the indictment or criminal prosecution of a sitting president would impermissibly undermine the capacity of the executive branch to perform its constitutionally assigned functions, in violation of the constitutional separation of powers. Given the role of the Special Counsel as an attorney in the Department of Justice and the framework of the Special Counsel regulations, this office accepted OLC's legal conclusion for the purpose of exercising prosecutorial jurisdiction. And apart from OLC's constitutional view, we recognise that a federal criminal accusation against a sitting president would place burdens on the president's capacity to govern and potentially preempt constitutional processes for addressing presidential misconduct. Second, while the OLC opinion concludes that a sitting president may not be prosecuted, it recognises that a criminal investigation during the President's term is permissible. The OLC opinion also recognises that a President does not have immunity after he leaves office, and if individuals other than the President committed an obstruction offence, they may be prosecuted at this time. Given those considerations, the facts known to us, and the strong public interest in safeguarding the integrity of the criminal justice system, we conducted a thorough factual investigation in order to preserve the evidence when memories were fresh and documentary materials were available. Third, we considered whether to evaluate the conduct we investigated under the Justice Manual standards governing prosecution and declination decisions, but we determined not to apply an approach that could potentially result in a judgment that the President committed crimes. The threshold step under the Justice Manual standards is to assess whether a person's conduct constitutes a federal offence. Fairness concerns counselled against potentially reaching that judgment when no charges can be brought. The ordinary means for an individual to respond to an accusation is through a speedy and public trial, with all the procedural protections that surround a criminal case. An individual who believes he was wrongly accused can use that process to seek to clear his name. In contrast, a prosecutor's judgment that crimes were committed, but that no charges will be brought, affords no such adversarial opportunity for a public name clearing before an impartial adjudicator. The concerns about the fairness of such a determination would be heightened in the case of a sitting president, where a federal prosecutor's accusation of a crime, even in an internal report, could carry consequences that extend beyond the realm of criminal justice. OLC noted similar concerns about sealed indictments. Even if an indictment was sealed during the president's term, OLC reasoned it would be very difficult to preserve an indictment's secrecy, and if an indictment became public, the stigma and opprobrium could imperil the president's ability to govern. Although a prosecutor's internal report would not represent a formal public accusation akin to an indictment, the possibility of the report's public disclosure and the absence of neutral adjudicatory forum to review its findings counselled against potentially determining that the person's conduct constitutes a federal offence. Fourth, if we had confidence after a thorough investigation of the facts that the President clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, however, we are unable to reach that judgment. The evidence we obtained from the President's actions and intent presents difficult issues that prevent us from conclusively determining that no criminal conduct occurred. Accordingly, while this report does not conclude that the President committed a crime, it also does not exonerate him. This report on our investigation consists of 4 parts. Section 1 provides an overview of the obstruction of justice principles and summarises certain investigatory and evidentiary considerations. Section 2 sets forth the factual results of our obstruction investigation and analyses the evidence. Section 3 addresses statutory and constitutional defences. Section 4 states our conclusion. Executive Summary to Volume 2. Our obstruction of justice inquiry focused on a series of actions by the President that related to the Russian interference investigations, including the President's conduct toward the law enforcement officials overseeing the investigations and the witness to relevant events. Factual events of the obstruction investigation. The key issues and events we examined include the following. The campaign's response to reports about Russian support for Trump. During the 2016 presidential campaign, questions arose about the Russian government's apparent support for candidate Trump. After WikiLeaks released politically damaging Democratic Party emails that were reported to have been hacked by Russia, Trump publicly expressed skepticism that Russia was responsible for the hacks, at the same time that he and other campaign officials privately sought information, redaction, about any further planned WikiLeaks releases. Trump also denied having any business or connections to Russia, even though as late as June 2016, the Trump Organization had been pursuing a licensing deal for a skyscraper to be built in Russia called Trump Tower Moscow. After the election, the President expressed concerns to advisers that reports of Russia's election interference might lead the public to question the legitimacy of his election. Conduct involving FBI Director Comey and Michael Flynn. In mid-January 2017, incoming National Security Advisor Michael Flynn falsely denied to the Vice President, other administration officials and FBI agents that he had talked to Russian Ambassador Sergei Kislyak about Russia's response to US sanctions on Russia for its election interference. On January 27, the day after the President was told that Flynn had lied to the Vice President and had made similar statements to the FBI, the President invited FBI Director Comey to a private dinner in the White House and told Comey that he needed loyalty. On February 14, the day after the President requested Flynn's resignation, the President told an outside advisor, "Now we have fired Flynn, the Russia thing is over." The advisor disagreed and said the investigations would continue. Later that afternoon, the President cleared the Oval Office to have a one-on-one meeting with Comey. Referring to the FBI's investigation of Flynn, the President said, "I hope you can see your way clear to letting this go, to letting Flynn go. He is a good guy. I hope you can let this go." Shortly after requesting Flynn's resignation and speaking privately to Comey, the President sought to have Deputy National Security Advisor K.T. McFarlane draft an internal letter stating that the President had not directed Flynn to discuss sanctions with Kislyak. McFarlane declined because she did not know whether that was true, and a White House counsel's office attorney thought that the request would look like a quid pro quo for an ambassadorship she had been offered. The President's reaction to the continuing Russia investigation. In February 2017, Attorney General Jeff Sessions began to assess whether he had to recuse himself from campaign-related investigations because of his role in the Trump campaign. In early March, the President told White House counsel Don McGahn to stop Sessions from recusing. And after Sessions announced his recusal on March 2, the President expressed anger at the decision and told advisers that he should have an Attorney General who would protect him. That weekend, the President took Sessions aside at an event and urged him to unresign. Later in March, Comey publicly disclosed at a congressional hearing that the FBI was investigating the Russian government's efforts to interfere in the 2016 presidential election, including any links or coordination between the Russian government and the Trump campaign. In the following days, the President reached out to the Director of National Intelligence and the leaders of the Central Intelligence Agency, CIA, and National Security Agency, NSA, to ask them what they could do to publicly dispel the suggestion that the President had any connection to the Russian election interference effort. The President also twice called Comey directly, notwithstanding guidance from McGahn, to avoid direct contacts with the Department of Justice. Comey had previously assured the President that the FBI was not investigating him personally, and the President asked Comey to lift the cloud of the Russia investigation by saying that publicly. The President's termination of Comey on May 3, 2017, Comey testified in a congressional hearing, but declined to answer questions about whether the President was personally under investigation. Within days, the President decided to terminate Comey. The President insisted that the termination letter, which was written for public release, state that Comey had informed the President that he was not under investigation. The day of the firing, the White House maintained that Comey's termination resulted from independent recommendations from the Attorney General and Deputy Attorney General that Comey should be discharged for mishandling the Hillary Clinton email investigation. But the President had decided to fire Comey before hearing from the Department of Justice. The day after firing Comey, the President told Russian officials that he had faced great pressure because of Russia, which had been taken off by Comey's firing. The next day, the President acknowledged in a television interview that he was going to fire Comey regardless of the Department of Justice recommendation, that when he decided to just do it, he was thinking that this thing with Trump and Russia is a made-up story. In response to a question about whether he was angry with Comey about the Russian investigation, the President said, "As far as I'm concerned, I want that thing to be absolutely done properly," adding that firing Comey might even lengthen out the investigation. The appointment of a special counsel and efforts to remove him. On May 17, 2017, the acting Attorney General for the Russia investigation appointed a special counsel to conduct the investigation and related matters. The President reacted to news that a special counsel had been appointed by telling advisers that it was the end of his presidency and demanding that Sessions resign. Sessions submitted his resignation, but the President ultimately did not accept it. The President told aides that the special counsel had conflicts of interest and suggested that the special counsel therefore could not serve. The President's advisers told him the asserted conflicts were meritless and had already been considered by the Department of Justice. On June 14, 2017, the media reported that the special counsel's office was investigating whether the President had obstructed justice. Press reports called this a major turning point in the investigation. While Comey had told the President he was not under investigation, following Comey's firing, the president now was under investigation. The president reacted to this news with a series of tweets criticising the Department of Justice and the Special Counsel's investigation. June 17, 2017, the president called McGahn at home, directed him to call the acting Attorney General and say that the Special Counsel had conflicts of interest and must be removed. McGahn did not carry out the direction, however, deciding that he would resign rather than trigger what he regarded as a potential Saturday night massacre. Efforts to curtail the Special Counsel's investigation. 2 days after directing McGahn to have the Special Counsel removed, the President made another attempt to affect the course of the Russia investigation. June 19, 2017, the President met one-on-one in the Oval Office with his former campaign manager, Corey Lewandowski, a trusted advisor outside the government, and dictated a message for Lewandowski to deliver to Sessions. The message was that Sessions should publicly announce that, notwithstanding his recusal from the Russian investigation, the investigation was very unfair to the President. The President had done nothing wrong, and Sessions planned to meet with the Special Counsel and let him move forward with investigating election meddling for future elections. Lewandowski said he understood that what the President wanted Sessions to do. 1 month later, in a private meeting with Lewandowski on July 19, 2017, the President asked about the status of his message for Sessions to limit the Special Counsel investigation to future election interference. Lewandowski told the President that the message would be delivered soon. Hours after that meeting, the President publicly criticised Sessions in an interview with the New York Times, then issued a series of tweets making it clear the Sessions' job was in jeopardy. Lewandowski did not want to deliver the President's message personally, so he asked senior White House official Rick Dearborn to deliver it to Sessions. Dearborn was uncomfortable with the task and did not follow through. Efforts to prevent public disclosure of evidence. In the summer 2017, the President learned that media outlets were asking questions about the June 9, 2016 meeting, Trump Tower, between senior campaign officials, including Donald Trump Jr., and a Russian lawyer who was said to be offering damaging information about Hillary Clinton as part of Russia and its government's support for Mr. Trump. On several occasions, the President directed aides not to publicly disclose the emails setting up the June 9 meeting, suggesting that the emails would not leak and that the number of lawyers with access to them should be limited. Before the emails became public, the President edited a press statement for Trump Jr. by deleting a line that acknowledged that the meeting was with an individual who Trump Jr. was told might have information helpful to the campaign. Instead, said only that the meeting was about adoptions of Russian children. When the press asked questions about the President's involvement in Trump Jr.'s statement, the President's personal lawyer repeatedly denied the President had played any role. Further efforts to have the Attorney General take control of the investigation. In early summer 2017, the President called Sessions at home and again asked him to reverse his recusal from the Russian investigation. Sessions did not reverse his recusal. In October 2017, the President met privately with Sessions in the Oval Office and asked him to take a look at investigating Clinton. In December 2017, shortly after Flynn pleaded guilty pursuant to a cooperation agreement, the President met with Sessions in the Oval Office and suggested, according to notes taken by a senior advisor, that if Sessions unrecused and took back supervision of the Rust investigation, he would be a hero. The President told Sessions, "I'm not going to do anything or direct you to do anything. I just want to be treated fairly." In response, Sessions volunteered that he had never seen anything improper on the campaign and told the President there was a whole new leadership team in place. He did not unrecuse. Efforts to have McGahn deny that the President had ordered him to have the Special Counsel removed. In early 2018, the press reported that the President had directed McGahn to have the Special Counsel removed in June 2017 and that McGahn had threatened to resign rather than carry out the order. The President reacted to the news stories by directing White House officials to tell McGahn to dispute the story and create a record stating that he had not been ordered to have the Special Counsel removed. McGann told those officials that the media reports were accurate in stating that the President had directed McGann to have the Special Counsel removed. The President then met with McGann in the Oval Office and again pressured him to deny the reports. In the same meeting, the President asked McGann why he had told the Special Counsel about the President's effort to remove the Special Counsel and why McGann took notes of his conversations with the President. McGann refused to back away from what he remembered happening and perceived the President to be testing his mettle. Conduct towards Flynn, Manafort and a redaction. After Flynn withdrew from a joint defence agreement with the President and began cooperating with the government, the President's personal counsel left a message for Flynn's attorneys reminding him of the President's warm feelings towards Flynn, which he said still remains, and asking for a heads up if Flynn knew information that implicates the President. When Flynn's counsel reiterated that Flynn could no longer share information pursuant to a joint defence agreement, the President's personal counsel said he would make sure that the President knew that Flynn's actions reflected hostility towards the President. During Manafort's prosecution and when the jury in his criminal trial was deliberating, the President praised Manafort in public, said that Manafort was being treated unfairly, and declined to rule out a pardon. After Manafort was convicted, the President called Manafort a brave man for refusing to break and said that flipping was almost ought to be outlawed. And then there's a redaction of a sentence at the conclusion of that paragraph. Conduct involving Michael Cohen. The President's conduct toward Michael Cohen, a former Trump Organization executive, changed from praise for Cohen when he falsely minimised the President's involvement in the Trump Tower Moscow project to castigation of Cohen when he became a cooperating witness. From September 15 to June 2016, Cohen had pursued the Trump Tower Moscow project on behalf of the Trump Organization and had briefed candidate Trump on the project numerous times, including discussing whether Trump should travel to Russia to advance the deal. In 2017, Cohen provided false testimony to Congress about the project, including stating that he had only briefed Trump on the project 3 times and never discussed travel to Russia with him, in an effort to adhere to a party line that Cohen said was developed to minimise the President's connections to Russia. While preparing for his congressional testimony, Cohen had extensive discussions with the President's personal counsel, who, according to Cohen, said that Cohen should stay on message and not contradict the President. After the FBI searched Cohen's home and office in April 2018, the President publicly asserted that Cohen would not flip, contacted him directly to tell him to stay strong, and privately passed messages of support to him. Cohen also discussed pardons with the President's personal counsel and believed that if he stayed on message, he would be taken care of. But after Cohen began cooperating with the government in the summer of 2018, the President publicly criticised him, called him a rat, and suggested that his family members had committed crimes. Overarching factual issues. We did not make a traditional prosecution decision about these facts, but the evidence we obtained supports several general statements about the President's conduct. Several features of the conduct we investigated distinguish it from typical obstruction of justice cases. First, the investigation concerned the President. Some of his actions, such as firing the FBI director, involve facially lawful acts within his Article 2 authority, which raises constitutional issues discussed below. At the same time, the President's position as the head of the executive branch provided him with unique and powerful means of influencing official proceedings, subordinate officers, and potential witnesses, all of which is relevant to a potential obstruction of justice analysis. Second, unlike cases in which a subject engages in obstruction of justice to cover up a crime, the evidence we obtained did not establish that the President was involved in an underlying crime related to Russian election interference. Although the obstruction statutes do not require proof of such a crime, the absence of that evidence affects the analysis of the President's intent and requires consideration of other possible motives for his conduct. Third, many of the President's acts directed at witnesses, including discouragement of cooperation with the government, and suggestions of possible future pardons, took place in the public view. That circumstance is unusual, but no principle of law excludes public acts from the reach of the obstruction laws. If the likely effect of public acts is to influence witnesses or alter their testimony, the harm to the justice system's integrity is the same. Although the series of events we investigated involved discrete acts, the overall pattern of the President's conduct towards the investigations can shed light on the nature of the President's acts and the inferences that can be drawn about his intent. In particular, the actions we investigated can be divided into two phases, reflecting a possible shift in the President's motives. The first phase covered the period from the President's first interactions with Comey through the President's firing of Comey. During that time, the President had been repeatedly told he was not personally under investigation. Soon after the firing of Comey and the appointment of the Special Counsel, however, the President became aware that his own conduct was being investigated in an obstruction of justice inquiry. At that point, the President engaged in a second phase of conduct involving public attacks on the investigation, non-public efforts to control it, and efforts in both public and private to encourage witnesses not to cooperate with the investigation. Judgments about the nature of the President's motives during each phase would be informed by the totality of the evidence. Statutory and constitutional defences. The President's counsel raised statutory and constitutional defences to a possible obstruction of justice analysis of the conduct we investigated. We concluded that none of those legal defences provided a basis for declining to investigate the facts. Statutory defences, consistent with precedent in the Department of Justice general approach to interpreting obstruction justices, we conclude that several statutes apply here. C18, 1503, 1505, 1512, 1512, 2C2, section 1512C2, is an omnibus obstruction of justice provision that covers a range of obstructive acts directed at pending or contemplated official proceedings. No principle of statutory construction justifies narrowing the provision to cover only conduct that impairs the integrity of availability of evidence. Sections 1503 and 1505 also offer broad protection against obstructive acts directed at pending grand jury, judicial, administrative and congressional proceedings, and they are supplemented by a provision in section 1512B aimed specifically at conduct intended to prevent or hinder the communication to law enforcement of information related to a federal crime. Constitutional defences. As for constitutional defences arising from a President's status as the head of the executive branch, we recognise that the Department of Justice and the courts have not definitively resolved these issues. We therefore examine these issues through the framework established by Supreme Court precedent governing separation of powers issues. The Department of Justice and the President's personal counsel have recognised that the President is subject to statutes that prohibit obstruction of justice by bribing a witness or suborning perjury because the conduct does not implicate his constitutional authority. With respect to whether the President can be found to have obstructed justice by exercising his powers under Article 2 of the Constitution, we concluded that Congress has authority to prohibit a President's corrupt use of his authority in order to protect the integrity of the administration of justice. Under applicable Supreme Court precedent, the Constitution does not categorically and permanently immunise a President for obstructing justice through the use of his Article 2 powers. The separation of powers doctrine authorises Congress to protect official proceedings, including those of courts and grand juries, from corrupt, obstructive acts regardless of their source. We also concluded that any inroad on presidential authority that would occur from prohibiting corrupt acts does not undermine the President's ability to fulfil his constitutional mission. The term corruptly sets a demanding standard. It requires a concrete showing that a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with the official duty and the rights of others. A preclusion of corrupt official action does not diminish the President's ability to exercise Article 2 powers. For example, the proper supervision of criminal law does not demand freedom for the President to act with a corrupt intention of shielding himself from criminal punishment, avoiding financial liability, or preventing personal embarrassment. To the contrary, a statute that prohibits official action undertaken for such corrupt purposes furthers rather than hinders the impartial and even-handed administration of the law. It also aligns with the President's constitutional duty to faithfully execute the laws. Finally, we concluded that in the rare case in which a criminal investigation of the President's conduct is justified, inquiries to determine whether the President acted for a corrupt motive should not impermissibly chill his performance of his constitutionally assigned duties. The conclusion that Congress may apply the obstruction laws to the President's corrupt exercise of the powers of office accords with our constitutional system of checks and balances and the principle that no person is above the law. Conclusion. Because we determined not to make a traditional prosecutorial judgment, we did not draw ultimate conclusions about the President's conduct. The evidence we obtained about the President's actions and intent presents difficult issues that would need to be resolved if we were making a traditional prosecutorial judgment. At the same time, if we had confidence after a thorough investigation of the facts that the President clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the President committed a crime, it also does not exonerate him. So that's the end of the introductory pages to Volume 2 of the executive summary of Volume 2, the introduction, yep. And so then it moves on into the details. So we'll have a break here and move on to the next one in the next video.